Welcome to Independent Truths with Scott Atlas, my new show that brings a uniquely rational perspective to important issues facing society today. Today's guest is Professor John Yoo. John is the Emanuel Heller Professor of Law at University of California, Berkeley. He's also a senior fellow at American Enterprise Institute and a visiting fellow at Hoover Institution of Stanford. John is a prolific author and scholar of constitutional law. His 10th book is called Defender in Chief, Trump's Fight for Presidential Power, that was published by St. Martin's Press in 2020. He is a regular contributor to the editorial pages of many of the country's most important newspapers, Wall Street Journal, New York Times, Washington Post, etc. John has served in all three branches of government, including being an official in the U.S. Department of Justice, where he worked on national security issues right after the 9/11 attacks. He has been general counsel of the United States Senate Judiciary Committee and was a law clerk for Supreme Court Justice Clarence Thomas. John graduated from Yale Law School and was summa cum laude from Harvard. We have an illuminating conversation today about many of the issues about civil liberties, freedoms, censorship, and all of the things that have been exposed by the pandemic and the management of the pandemic. I think you'll find it very illuminating. Thanks for joining us and stay tuned. John, welcome. Great to have you here today. Thank you for doing this.
Oh, thanks, Scott. It's great to be with you. I'm glad to see you got this new show going.
Yes, interviewing all kinds of people because there's so many things happening in the world today. It's actually quite amazing. There's so many things to talk about with you specifically. Given that you are such a scholar of constitutional law, I would like to explore some specific topics about what we've seen during the pandemic, what has been exposed about the state of things and the freedoms that we have as Americans vis-a-vis the constitutional prescriptions for those freedoms. And the first thing is the sort of a fundamental question. We've seen now almost 2 years of a presidential decree of a public health emergency in the United States, which I think is beyond what anyone had assumed would happen. And of course, it's arguable if there really is an emergency of public health at this point. But I sort of want to get to, what is the legal definition or the constraints for issuing such a decree? And I'd like to talk about the implications of giving that decree because that has specific there's a reason why that statement is made because it has a lot to do with things, drug discoveries, the mandates, and all this.
The first thing to keep in mind is that the power of declaring a public health emergency is not inherently presidential. If you were opening up the Constitution, you would not see the words public health or emergency in the text. You certainly would not see it under Article 2, which is where the presidency's powers are set out. To the extent there is a power in the federal government to declare a public health emergency and then to take measures to combat it, it's up to Congress. Congress passed something called the Public Health Services Act, really back in the 1940s. And a lot of these laws are quite old and have never really been tested as they've been tested these last few years. And it's there that Congress gave the executive branch the authority to declare a public health emergency. Yeah, but as you know, Scott, as I know, when Congress sits down to write laws, they're never really very specific. And so
Right.
they didn't really define what a public health emergency was. I mean, it basically just says an emergency, about a threat to public health. And it doesn't say what kinds they are, doesn't certainly list any kind of list of diseases or illnesses that would qualify. The Congress leaves it up to the executive branch. And one other thing is, as with many things in our Constitution, the courts are involved. The statute, the the Public Health Services Act, doesn't say courts aren't allowed to review the declaration. It doesn't say Courts aren't allowed to hear cases about individual liberties during such a declaration. But because Congress wrote the statute in such a vague way, it doesn't address the questions that you're raising, Scott, which is how long can an emergency go on for? What qualifies for an emergency? Do the powers of the government get broader or narrower based on the type of public health emergency? One other point then about the general background of the law of public health emergencies is under our Constitution, the powers of the federal government are supposed to be limited. That's one thing you would get if you breezed through our very short Constitution. Our founders gave the federal government what we call enumerated limited powers. In fact, the federal government is not responsible for public health throughout the country. The way our Constitution works is that most of the powers over domestic affairs are assumed to reside with the states, where they had always been and were at 1789 at the time of our ratification of the Constitution, and that the federal government just sort of intercedes in specialized areas where you really need a federal government. So, in general, when you have a public health emergency, the primary regulator, the primary role should be played by states, not by the federal government. And the federal government's supposed to be playing a backup role. It can provide money for research, or it can buy PPT, or it can provide information, or it can provide guidelines. But our Constitution, when it comes to public health, as it does with crime, as it does with all kinds of almost most affairs in our lives, it's really the states that are supposed to be the primary decision makers. And so even if President Trump or President Biden declares a public health emergency, that doesn't suddenly give the federal government, under our law, vast powers to regulate everything and everybody in the country.
Right. I think what was confusing and sort of disconcerting in this pandemic, at least to me, was there were a couple things going on. One was that there was a sort of a desire for elected officials to hide behind someone else's declaration. And what I mean by that is, while the governors were up in arms at the beginning of this, saying they want to be in charge of their own states, they were anxious to have a federal declaration of a public health emergency or mandates or policies so that they could just say, in my opinion, they were just saying, well, we're going to go with what they say. Particularly the CDC, federal health agencies, became a sort of rule setters rather than simply advisory bodies. And similarly, this happened under two administrations in a row. It's happened where there's a common statement made, well, whatever the CDC suggests, that's what we're doing, as if the elected leaders are not actually responsible for the decisions. Has there been such a situation in the past where there's been such, in my way of thinking, a desire to abrogate the authority to others? I think it's sort of surprising that happened, because people that run for office, particularly executive level positions, want the authority.
Yeah, Scott, that's a good point. Sadly, it's all too true. And I think many levels of government. Look at the vast administrative state we have now. HHS, look at all the money it spends, all the things it does, all the functions it's taken on, which used to be the job of the states. What has happened at the federal level, and you see this with the Public Health Emergency Act, is that Congress delegated all these powers to the executive branch, to the agencies, because the members of Congress didn't want to take political responsibility for any of the decisions having to do with COVID. They were happy to spend lots of money, but actually figuring out, like, what should we do? What should the policies be? Right? You would have members of Congress just saying, "Oh, we just want the experts to tell us." This is very much a part. This is very much a part of going back 100 years. This is Weber's description of bureaucracy. This was Woodrow Wilson and the original progressives' idea, was to take away power from those dirty politicians and transfer it to these experts who would become neutral and divorced from everyday pressures of politics, and they would come up with the right answers. Right? That's very, I think, contrary to the American system of government and the way our Constitution was set up, where we're a republic where we elect people, and those elected people make the policies, and they are accountable to us. One thing then that we saw, as you described, Scott, is that this is now happening at the level of federal-state relations. So it's not just Congress delegating power to these experts so they can wash their hands of difficult decisions. But it's now you saw governors saying, oh no, I'm doing this because those experts in Washington think this is the best policy. I think actually it's quite different than what our founders thought when they set up our federal system, where they thought states could have different policies. The reason we have states at all, one of the reasons is because the country's large and diverse, and
Right.
you would want to have different decisions made and different policies for different parts of the country. That you don't need to have lockdowns, for example, in largely rural, sparsely settled parts of the country where it's easy to walk outside, look out the door, and not see anybody. Why would you need to wear a mask? Those rules might be very different in a very dense city. Federalism accommodates that. So I agree with you. I was really struck also, Scott, not just at the beginning, but during the pandemic, how many states sort of willingly gave up, in a way, their authority to make the decisions about the pandemic, because that's what our Constitution expects of them. That's what our political system expects of them, is for the states to make those decisions and not to defer to
Right.
bureaucracy.
Yes, yeah, and it's easy to guess, it's hard to know the motivation, but I think the fear of the disease by the people in power, I think, was an under acknowledged factor, uh, and they're in a fear of sad fear of a failure of leadership, frankly, of people who were elected to lead and take the responsibility for the for leading. I mean, the leadership positions are not just for sort of having power. There's a responsibility. The burden is the responsibility. You have to step up and take it. I do want to explore one part of the declaration of a public health emergency, and that is the reason that it's done is not just to tell people what to do. There are sort of specific things that can be done about, for instance, rapidity of drug approvals, emergency use authorizations. And I wonder if you think that will be undergoing scrutiny now. We know there will be more public health emergencies. We know there will be other crises of a variety of forms, even the pandemic specifically. And I wonder if we've learned some lessons about that, or if we're going to still see that again. I wonder what your thoughts are on that, and if laws need to be revisited for specifically constraining the duration of a public health emergency, or a more rigid definition, because as you said, these definitions don't really exist.
Now, this is really interesting from a constitutional perspective. This is one of the most important consequences of the whole COVID emergency, was that I think the Biden administration has gone so far in stretching beyond the real limits, its delegated powers from Congress, that the courts have finally woken up and are placing, for the first time, some fairly pretty careful review of what the executive branch is doing under the guise of these emergency declarations. In the past, and this is just not public health emergencies, it's also national security emergencies, war, and so on, the courts have always been reluctant to say whether something really is an emergency or not. They would say, "Oh, we're courts. We're not out there running fact-finding expeditions and
Mhm.
having hearing. It's up to the legislature and the president to decide whether there's an emergency, whether the facts on the ground justify declaring an emergency." And the courts have generally deferred to the decisions of the elected branches, and I think wisely so. The problem is that the Biden administration has so stretched its powers, I think, and as the court has agreed, beyond the law, that the courts are now becoming quite skeptical of the national emergency in the public health area. And they're saying they're quite willing now to block the executive branch. This has never really happened before, to block the executive branch's decisions. So just a few of the decisions, as you mentioned, I think earlier, restrictions on religious worship. Uh, the court initially said that they would allow states to place churches, synagogues, places of worship under restrictions, lockdown restrictions. But then, about a year into the lockdowns, the court said, no, you can't treat churches and synagogues differently. At the
Mhm.
very least, they should be treated the same. But so the court, I think Justice Gorsuch notably wrote, well, you're saying bike repair shops are allowed to be open, but churches can't? That violates the freedom of religion.
I
Then
think
the
this, if I can interrupt here,
Yes.
this is really one of the things that ordinary people and non-legal minds like myself understood, that there was a break in common sense here, that why it was so selective, certain businesses,
Mhm.
certain assemblies, if you will, could be maintained, whereas others could not, including those explicitly designated as an essential freedom, like freedom of assembly, freedom of religion
Yeah.
specifically. I think this is one of the big sort of keys to making the public not accept some of these lockdown measures, was because the common sense of it seemed to be violated. The public was lost on that sort of there was no rationale for that, it seemed, beyond the law itself. It just seemed very selective. And I think one of the other things that we saw anecdotally, where people were not just limited in their freedoms to move or to congregate, but there were certainly a lot of anecdotal stories about people being unable to visit their relatives in hospitals, their sick
Mhm.
relatives, their sick mother and father, including, in some cases, unable to check them out from the hospital. It was very, very, shocking to me, the limitations on rights that we assumed we had.
Yeah, exactly. And usually during an emergency, and actually when it comes to general policy, the courts will usually say, as long as it seems rational what the government's doing, we're not going to say the law requires the government to implement the best policy. We're just going to test to see if what they're doing is just minimally rational. And as you point out, Scott, a lot of the things during the lockdown policies didn't even seem to pass that test. And the courts started to, all right, say, why are you closing churches when you're keeping open bike shops and I think marijuana dispensaries? I think that was another
Mhm.
example that the court just found inexplicable. Then I think another area where the court has become even more skeptical is the Biden administration. I think, according to the court, appears to be using the emergency as a pretext to legislate in other areas. Right? So right now, the court has taken this case about student loans. Right? What does the national emergency of public health really have to do with forgiving the student loan debts of millions of people to the tunes of hundreds of billions of dollars? I could see a case for saying, well, maybe during the period of a public health emergency when we're saying you're not allowed to go to work, the government might say, we'll suspend payments until things get back to normal. But to say we're just going to cancel everyone's debts based on
Right.
income, the court has taken that case. They're going to hear arguments on it this year, and I think the court can't escape the realization that the what the Biden administration is really doing is that they're just trying to use the public health emergency as a guise to protect all these other economic and social policies that has wanted to achieve but can't get through Congress.
Yeah, and
Uh, just one
I
other
was gonna say
example.
that.
Oh,
Oh, go ahead, John.
well, just one other example of that is the court struck down this ban on evictions throughout the country. And I
Right.
think this was a really extreme exercise of federal power. Basically, the federal government went ahead and amended every landlord tenant contract in the country, which most scholars, I think, generally would agree the government doesn't have the power to rewrite every contract on landlord tenant law in the country, and said no one's going to be allowed to be evicted. You could be years behind on your payments. You could trash your apartment, so on and so on. You could decide not to pay anything at all, and live there rent free for 2 years, 3 years, as long as the public health emergency goes on. And the court said it was really remarkable because this court really hasn't intervened in economic policy since the 1930s. The court said, no, we're not going to allow the Biden administration to claim public health emergency and then have right, just like a free ticket to do whatever it wants. There has to be some sign that Congress wanted the executive branch the ability to have this power over such an important social and economic reason. And the court then followed that with another decision striking down the nationwide vaccine requirement on similar
Right.
grounds. The court said, yes, there might be a public health emergency. Yes, there are different things the laws allow you to do. The law has never said that the government can basically force every American to take a vaccine. Maybe that's up to the states. California could require vaccines, but the federal government can't because it's a government of limited powers, as we said earlier. And so the court remarkably struck that law down too. So, it's just an example. The Biden administration has been using these public health emergency powers so broadly that they've actually ruined the kind of confidence and deference that the courts used to display for a century, really, to
Right.
the government and how it handles emergencies.
Sort of it's interesting that Tocqueville wrote, I think, that the last mainstay of the United States of America against tyranny, what he called tyranny of the majority, was the court system. So we're sort of seeing some of that come into play. The other observation that I personally make and others have made it is that this was always framed, the pandemic was framed in terms of this is a war. And when you invoke that kind of terminology, it's very persuasive on the public, and I think that's why it was used, but it was also, it sort of set up the in a way, the legal sort of, comparison, if you will, and maybe I'm wrong about that, but I sort of think it was there's an analogy here, this is wartime, and in wartime, almost anything goes. And because we have not had lockdowns really like this in a public health case. In fact, the standard lockdown policy was already it was already known for 15 years plus that lockdowns were both ineffective and harmful, and they shouldn't be used. They were not recommended. So this was really the first really severe draconian lockdown that was used. But I think it was used in a way as if it were wartime. And I think it really did, as you said, it has become it was abused in the beginning, but it certainly has become abused and almost an excuse for doing all kinds of things. And that is really the reason, in a non-legal way, why the terminology public health emergency has been renewed over and over again when the pandemic there is no public health emergency, and yet it's being renewed and was renewed through the spring of this year, 2023. I'd like to talk as an issue about what we've seen with freedom of speech, and what we know, as you clearly know, and what I personally and many others experienced was that there were restrictions on speech that were sort of shocking during this pandemic, shocking to people like me who were naive about that sort of thing. Being a university professor, where universities are supposed to be the centers for the free exchange of ideas, but it wasn't just university indirect or nuanced censorship or censure or harassment or bullying. It was actually now that we've seen evidence of censorship directly by social media and directly in conjunction with our government. And I think this is really, at least to the lay public like myself, unprecedented, shocking, since we're a country that is founded on and based on these freedoms. How is this going? I'd like you to hear what you think about what's happening with this, the idea, and also of the censorship, and especially in social media, which again, it's complicated. These are private companies, and how important it is that we actually see evidence that the government was involved in directing it.
This is also going to be one of the major issues that comes out of the pandemic was, as you say, I think what we're learning now about what social media was doing to try to influence debate, to suppress opinions it didn't like, was incredible and shocking. And now what we're learning about the government being involved with the decisions of social media here, uh, yeah, I agree, it's even more shocking. And I think what's here's how I would think about it is, um, if there were no government involvement at all, there's still an interesting question whether Google, Facebook, Twitter have an obligation to be an open forum for the speech where they don't discriminate on the basis of viewpoint. So, uh, obviously, if it was just normal private property, like your front yard, my front yard, we're allowed to put whatever signs we want on there. We're allowed to kick people off we don't want on our front yard. We can decide not to speak at all and just leave our front yards open and not put any campaign signs. And that's the traditional rule. But there's long been a doctrine called the common carrier idea. I think I spoke about this at your Hoover Institution, your Hoover
Yes.
Institution, policy boot camp, where we've always had exceptions to that principle. Private property owners control their property and they can have whatever speech they want. When it comes to large networks that provide important social benefits, where there's basically a monopoly. So United Airlines can't kick Nancy Pelosi off because they don't like Democrats. The utility company can't say, "I'm not going to, hook up Gavin Newsom to the electrical grid because we don't like Democrats." Certain kinds of networks, like utilities, transportation networks, and so on, AT communications, like AT&T and Verizon, they are not allowed to discriminate because they are essentially a monopoly. And so I actually think the legal system is moving towards treating Google and Facebook and Twitter in that same way because they essentially now are they essentially hold a monopoly over how most Americans participate in public speech and the discussion of politics. Uh, so even before you get to the government being involved with, right, what do they call it, shadow banning or outright
Right.
banning people, I could see the courts eventually forcing these companies to follow a non-discrimination policy anyway. But in this particular case, and this is why I say COVID again, it's an example again, just like with Biden going too far and the courts slapping them back, the administration back. Here's another example: the social media companies went too far; they abused their power, and because of that, they're going to spark, I think, this reaction by the legal system, by the courts, and COVID accelerates that because now we're learning that the White House or the FBI was suggesting to these social media companies, "Oh, you should take a look at this person's speech. You shouldn't let this person's uh, tweets or comments spread or be easy to find." That would be potentially illegal because in a standard First Amendment law, the government, right, can't ban people's speech, and the government can't basically be in cahoots with other people to ban the speech. So
I mean, this seems to be more of an obvious legal
mhm,
break here. There's not a lot of ambiguity on the way the government has acted here, it seems to me, and I'm asking this.
mm.
Whereas in a private company, in a funny way, would seem possibly to be able to defend itself because they were told to do this by the federal government. What does that mean in reference to the private companies and their liability?
Well, the federal, in these cases, you look at these tweets. I don't think this is a very good defense for Google or Twitter or Facebook for them to say, "Well, we were coerced by the government," because if you look at the tweets, you don't really see it that ham-handedly. You see something more, like what you see in mafia movies or something, where the government just says, "Oh, this is a great network. We regulate you in lots of different ways. Could you help us?" And
Right.
so I think that I mean the government's going to be liable because the government's not allowed to try to skirt around its free speech obligations by you know pushing private actors to do it, but the private actors were conspiring with the government to do it. I think they're both going to be ultimately liable in some way to people who are banned. Uh,
Hmm.
I think, as you say, I think this is an easier case than the harder one, which is just Twitter banning people. Elon Musk banning people he doesn't like from his own personally owned network. I think we're going to get to the point where those networks are going to be required to be fair and open to everybody. But the fact that these networks were conspiring with the government to blackball disfavored speakers is just going to get us there faster.
What about the whole quagmire of these companies having boards of accepted or misinformation? And this misinformation is not just about these companies. There's a new law, as you're well aware, in California on medical licensure, where the medical licensure board has, I think it was October 22nd, 2022, put in a law that said for specifically COVID, but misinformation, which was by their definition, anything that it deviates from what they considered community standard of care,
Mm.
is a cause for revocation of a medical license. I mean, this is a different sort of freedom of speech issue. In a way, in many ways it's more harmful because, as you know, I think as everyone knows, and as you know as an attorney, and I know as a doctor, the way medical dialogue goes between this sort of relationship, the so-called doctor-patient relationship, was sort of a sacred part of the way medicine is practiced. And medicine is individual. Not it's an art and a science, as they say. And so, how do you see that going? Because that seems to me, as a doctor, completely antithetical to the way science and medical science is done, as well as clinical practice. Medicine is not by consensus, first of all, and medical science changes, and so misinformation is at the eye of the beholder.
Yeah, this is, I think, another sad consequence of COVID, as we saw. You and I saw it up close, being university professors, is uh, the extent these great American institutions, law, medicine, science, universities, thought they should be in the business of censoring thought and speech, when actually openness of thought and speech is critical to, right, the scientific method, or critical to medical advances or legal advances. And so the sad thing is you're seeing this go on with the professions now, with the medical boards saying we're going to tell doctors what they're allowed to say and not say to their patients, particularly in an area where there's still a lot of debate about what's happening, what's good policy or bad policy. And just to compare, it to be as if the bar for lawyers said you're just not allowed to make certain arguments in defense of your clients. You're not even
Right.
allowed to talk to your clients about certain kinds of defenses they might raise in court. And suppose they're disfavored. Suppose they were to say, "Oh, you're not allowed to, because we, the bar, or we, the medical board, we believe so much in diversity. We're not going to allow our lawyers to challenge diversity, right? Or we're not going to allow doctors." It's the same thing, it seems to me. And so I expect that these kind of restrictions are going to lose in the end in our courts. That our courts will see that these are not really, this is the right way you do a certain specific delicate operation, right? And this is the way you should do it. Um, but it's really about censoring the speech of doctors, or censoring speech of lawyers, or trying to censor the speech of professors. And ultimately, we all lose, as you say, Scott, because, right? Think about if Galileo were around. Right? Was he engaging in misinformation, right, by saying the sun was at the center of the solar system? Uh, Under the rules of the day, our university administrators would have been in the same position as the Vatican bureaucracy holding a trial of Galileo. Uh,
Right.
we all lose because it slows down our ability to find the truth, and which is for the better of our country and society. And it's a terrible
Absolutely.
thing our institutions are tinkering with these the scientific method or legal arguments, the way of critical thought that have served us so well for centuries, just over because of the
Absolutely.
COVID pandemic.
I couldn't agree more. I mean, what's frightening, and you've heard me say this, is that it took the Catholic Church 359 years to admit that Galileo was right and the Earth moved. And I'm a little bit concerned. I'm very concerned that we're going to be very slow in putting forward the remedies for this sort of thing because the public is being harmed tremendously by the lack of this ability to talk about things freely, and we will never arrive at the truths that we need in future crises, and these are inevitable. So, yeah, it's very frightening. We have a lot of work to do, a lot of things to discuss, and I think the discussion of the issues themselves about the lack of discussion, if you understand what I'm saying, is very important to make the public aware because I think most people really want the freedoms that we all thought we had. All right, John, I think I'll leave it there because I don't want to take too much of your time, but it's always great talking to you. Thank you so much for doing this, and I hope that we can have you back.
Oh yes, Scott. Thanks for having me. I look forward to. I feel like we only scratched the surface of a lot of the things we have, our interests that we have in common. So I'd love to come back and look forward to more episodes of your podcast.
Great. I'm going to take you up on that. Have a good day. See you later.
Bye.
Thank you for listening to Independent Truths with Scott Atlas. If you want to find out more about today's guest, Professor John Yoo, please check out his links at the University of California, Berkeley Law School and at Stanford University's Hoover Institution. And don't forget to subscribe to our show on YouTube as well as Spotify, Apple, Google, and anywhere else that you're listening to podcasts today. And I'll see you next time.